Good afternoon, everyone, and thank you for joining us for this panel event. My name's Andrew Lang. I'm a Professor of International Economic Law at the University of Edinburgh, and it's my real pleasure to chair this session on judicialization and dejudicialization in global economic governance. As that title suggests, the purpose of our conversation today is to reflect together on more than 30 years of judicialization in the realm of global economic relations, and really to try to situate contemporary discussions about the crisis of judicial dispute settlement, or backlash, if that's the right word, against international judicial tribunals in much larger historical perspective. So the format of our session today is conversational. Our panelists won't be presenting papers, but instead responding to a series of 3 questions from me as moderator, drawing on their recent work in this area. And this work will be known to many of you as canonical within the field, and I'm really delighted that we've been able to convene this conversation between this particular group of folks. So it promises to be most interesting. The first hour and a bit of our session will consist of this conversation amongst our panelists, and then we'll be able to open up the session to a live question and answer session. As a result of scheduling difficulties, this opening session will be recorded, and I'm disappointed to say that I'm not able to join you live to moderate the Q&A session. This will be done by Maria Laura in my absence. So let me very briefly now introduce our 4 panelists in the order that I see them on my screen. So Karen Alter is Professor of Political Science and Law at Northwestern University. Her work on the judicialization of international law has helped to define the field. And in her recent work, she's focused on developing a concept of dejudicialization, situating it within larger trends within global economic governance, as well as re-theorizing the notion of backlash. Quinn Slobodian is Associate Professor of History at Wellesley College. He's a historian of, among many other things, international history, with a focus on North-South politics, social movements, and probably most relevantly for our conversation, the intellectual history of neoliberalism. His 2018 book entitled Globalists, The End of Empire and the Birth of Neoliberalism touches on a range of events and people and issues of direct relevance to our conversation today. Ignacio Garcia Bercero is Director at the Directorate General for Trade of the European Commission, DG Trade. He has deep professional experience in the area, having joined the Commission in 1987 and indeed participated in the negotiation of the present WTO dispute settlement system. He currently oversees, for DG Trade, activities related to multilateral affairs, strategy and economic analysis. And Maria Laura Marceddu is a former colleague of mine at Edinburgh Law School and currently serves on the Executive Council of SIEL, and she'll be joining the EUI on their Max Weber program in September. And her recent work focuses on the place of rule of law values in the EU legal system. So welcome to all of you, to all of our panelists. Thank you so much for your time. Thank you for agreeing to participate. So to our conversation, let me turn now to the first question for our panelists, which is really designed to set the stage by looking at the historical conditions of possibility for the present judicialized system. So the set of questions that we want to start with are these. What does it mean to say that the present system is judicialized? In what sense is that an accurate description of the system, which has been built, as I say, over the last 30 years or so? And importantly, what were the conditions in which this judicialized system came to emerge and then initially at least flourished? What forces gave rise to it? And here I want to turn first to Karen to hear her response. Thanks, Karen.
Thanks. Quinn, could you put up the slides? So judicialization just requires 2 necessary conditions. The first condition is basically a structure, an opportunity structure to take a legal dispute. Judicialization means taking a political dispute into the legal arena. So you need litigants, lawyers who want to take it into the legal arena. And Quinn, can you advance it for a second? And you need a legal arena for them to take it to. Now, typically the conversation is only about international courts. But the way we defined what a legal body was for judicialized politics, it's not just international courts. It's anyone that has the formal authority to decide concrete legal disputes between contested parties. They're independent decision makers that apply legal tools, pre-existing rules and procedures, review facts, evidence, legal claims. They reach an authoritative determination, binding or non-binding, and they make orders or suggest remedies for legal violation. Those are the only two conditions. And I want to stress that. Go ahead and advance the slide, Quinn. Because really you just need binding law and a body that can enforce it. So when I start to look at the international economic realm, and this is a piece that's not yet appeared, and I say, where is this binding law coming from? Well, it might be coming from international law or multilateral international law, but it's also coming from private contracts. It's also coming from domestic extraterritorial law. It also might be enforced in certain domestic arenas. So then if we go to what was happening in international context, go ahead and advance the slide, Quinn. There are two more. So the economic advances from my book, The New Terrain. And I put in green like a stoplight. Green, go, yellow, stop, slow down, and red was stop. And what we see is in the 40s and the 50s, there was not a big taste for judicialization of politics. And especially in the economic realm, they thought it was some people thought it was a bad idea. I mean, the ITO was not going to be highly judicialized, and then the US rejected it. And the European community was not intended to be as judicialized as it became. And the European states actually rejected the political and defense communities. And the common market was really much more institutionalized. It was more like a blueprint. The United States rejected the Organization for Trade Cooperation, an effort to try to create an institutional structure for the GATT. And you didn't really get judicialization during the period, partly because at the same time what is happening is developing countries are wanting to change the economic rules of the game. So if you had to use a multilateral forum to create binding legal rules and binding enforcement mechanisms for it, it would have to be shaped by what developing countries wanted. And in the 60s, developing countries were challenging even the very nascent dispute settlement system of the GATT. So the US and Europe stopped adjudicating in it. And there really weren't the structures that you could use to push your agenda, except for in the in the European Union. And so I think it's great that we have Ignacio here, because actually the first moves towards legalization, they came in Europe, and even in the economic Jacksonville and the Cassis de Dijon rulings are rulings in the 70s that the commission was really pushing basically the same ideas of GATT law, but they were solidifying GATT law in the European Union context already in the 70s. Let's go to the next slide, Quinn. Because the judicialization is really a post-Cold War phenomenon. That's when you start to see this taste for more enforceable legal systems taking place. And I talk about how this came about in my New Terrain book, but I forgot to highlight on the previous slide some seeds that were planted, like the New York Convention, which makes domestic legal rulings or arbitration rulings portable and enforceable around the world. That was actually created in the 50s, and I don't think anyone had a master plan of what it would become, except for when I read Quinn's book, all of a sudden I say, oh my gosh, maybe someone did have a master plan. Because when I look at the negotiating international level and what's going on, it seems like there's so much resistance to this idea of judicializing, making these hard law enforceable obligations in the 60s and in the 70s and even in the 80s. And it's only at the end of the Cold War and what happened in the 70s, maybe go back one slide, Quinn, is that the US passed its Trade Act in 1974, and then we hardened that Trade Act in the Super 301, and the US just started unilaterally enforcing. We're saying, we're going to say if you violated trade rules, and then we're going to put sanctions on you. And that was tremendously unpopular. So what I talk about in my New Terrain book was Europe and the US start enforcing these international rules, and if the choice is to let the US or Europe enforce these international rules, well, then you'd rather have an international body enforce it. I'm going to stop there. You can end the slides, Quinn.
Thanks so much. I'm just going to wait, Quinn, for you to stop sharing your screen. Brilliant. Quinn.
Yeah, thank you. Thanks to everyone for showing up for this, especially on the American holiday when we're recording. I think it's a good way to start the sort of the broadest possible question, which is kind of, what is judicialization and how would we know it when we see it, right? Because I think that, as Karen has made clear in some of her own previous work, which I found very helpful, it's not actually adequate to sort of just tally up the number of, let's say, international tribunals and courts, right? I mean, I think it is sort of necessary to think about judicialization the way political theorists think about sovereignty, which is not just a kind of a property that is out there or a kind of quantitative quality of things, but it's a claim, right? And it also, it's a part of a repertoire of political rule that can be drawn on by actors, and it can also, in many cases, if you're powerful enough, be set to one side or ignored, right? So I think that if the last few years has taught us anything, is the apparent consensus, what Karen called the kind of high watermark of judicialization around 2014, was kind of not a permanent state of affairs, right? So it's an interesting time to look now to sort of say, what was it that gave this judicialization thesis sort of the quality of permanence when it did for social scientists, for civil servants, for people operating probably in places like Brussels? And then what are the conditions under which it's been kind of denaturalized, or how has it sort of lost its sense of consensus, right? In the intervening moments, and what can we learn about the impermanence ultimately of what it was in the first place, even at its high point? And in that sense, I think it's, to walk back a bit and ask the second question, or answer the second question, what were the conditions under which this perceived judicialization anyway took place? I think that then you at least need to take it apart into two pieces, right? I mean, you need to talk about the material conditions and then the kind of ideational conditions that made it possible. And in terms of material conditions, there's just a whole story about kind of the realpolitik needs of the United States economy after the end of the Cold War, right? That made Congress open to these kind of arguments, that made it seem to them like this was something that they would gain more rather than lost. It made even people like Lighthizer, who now is, of course, the sort of firebrand anti-WTO spokesperson par excellence, able to advise Bob Dole in the mid-1990s that it was a good idea to sign up for something like WTO, right? So there's that story. This is a political economy story. Why did American interests align in such a way to make an opening for this? But that doesn't answer the question of where the idea came from in the first place, for which there was now an opening, right? And that gets to sort of Karen's, I think, point about the master plan, such as it existed, right, before the moment of judicialization. And there I agree, it's worth looking at the kind of the development of legal thinking that emerged in the period of decolonization as empire was ending. And the problem was posed, how do you create a system which will retain the conditions of capital security over borders, private rights over borders, the rights of investors to safeguard their investments in other countries other than their own. These were problems that were no longer going to be overseen just by the imperial hegemon, imperial overlords. In an era of self-determination, in an era of radical claims of national autonomy coming from poor countries, you needed something new. And it wasn't immediately clear what that would be. This actually happened to me yesterday. I have a fire alarm in my building. Okay, I guess I'll have to leave it there and just turn my mic off and hope that this stops.
Thanks, Quinn. And this is part of the new world, isn't it? To the extent that you have more to say, and we come back to you, feel free to finish that thought off later. Ignacio.
Okay, now thank me here, and what I would like to give you is some indications about why I think that the decision was taken in the context of the Uruguay round to move towards a more judicialized system of dispute settlement when compared to the GATT. Now, first, I think one really needs to look into the historical context. If you look into the trading system between 1971, the end of Bretton Woods monetary system, and the launch of the Uruguay round, this was a time of high turbulence in terms of international economic relations. It was a time when it was generally considered that the GATT as an institution was not fit for purpose, but there were growing conflicts between the United States, the European Union, and Japan, and where the GATT dispute settlement system, we have been doing modest, useful work during the 60s, stopped basically to function. And I think it was this actual historical context, which in my view led to a situation in which the United States defined as one of its fundamental objectives in the Uruguay round negotiations to have a system of dispute settlement that was more effective, that implied doing away with the rule of consensus. Now, I would like to emphasize that this was fundamentally a demand put forward by the United States. The European community at the time was rather reluctant. We were actually very much arguing in favor of maintaining a more diplomatic approach to dispute settlement. We were, until the very end of the negotiations, a strong defender of the rule of consensus, which is a bit counterintuitive in the narrative which is sometimes developed these days, as if judicialization of WTO dispute settlement had been a European project based on our own experience about the role of the ECJ in the internal legal economic order. That was not the reality about how the establishment of WTO dispute settlement was actually established. Now, the main conclusions which I would draw from this is that first, there was a general sense at the time we were actually establishing the WTO that if you actually wanted to have a system of dispute settlement that was effective and legitimate, you inevitably had to have some degree of judicialization. And the main reason why it was decided that it was necessary to establish an appellate body is because it was considered that ad hoc diplomats, which were basically staffing panels, would not have the same authority in terms of giving a final ruling as a body which had more of a judicial characteristics. Now, the second point is that, of course, this did not in any way imply that there was any idea that one would be delegating to such a judicial body lawmaking powers, or the power to take a policy role which properly belongs to the negotiating function. That was certainly not the intention of the United States. I would also very much argue it was not the intention of the European Union. So I would say, yes, there was a clear shift towards judicialization as a result of the importance attached to having international economic relations that could be based on greater stability and predictability, but it was certainly never intended that it would imply shifting of power towards a judicial body that would have broader powers. And I would argue that actually in no case has the European Union been actually supporting a role for the judicial institutions of the WTO, which is comparable to that of the ECJ under the domestic legal regime. There has always been a very clear distinction between what we see as the proper role of the ECJ within the European legal order and the proper role of the appellate body within the international legal order. And as you know, the European Commission has always been strongly against any idea of giving direct effect to WTO law in the European Union legal order. So I would just say that in terms of the overall historical context.
Thanks so much, Ignacio. Maria Lara.
Okay, I think I'm going to briefly follow up on what Ignacio just said about what we can describe as the law of unintended consequences that in a way open the way for judicialization, which seems to be clearly something unintended, at least originally. And I think this resonates well with what I wanted to say, what I want to say about the European Union, because I think the European Union, and specifically the use of judicialization that the European Union has made recently, are indeed a case in point. And I think I'll be moving from the historical origins underpinning the process of judicialization towards a more contemporary meaning of judicialization, borrowing, being inspired from what the European Union has been doing so far. And my intuition is that I can see that judicialization has now been used, especially, let's say, over the last decade by the European Union as an instrument to pursue multilateralism, to induce change, and also, of course, to advance economic, to a lesser extent, also political integration. I understand that this hardly comes as a surprise to many of us. I mean, after all, the European Union was the birth of certificate of the European Union, as Wangen-Laws very poetically, if you want to put it, it's an ordre juridique nouveau, it's a new legal order. So this idea of judicialization, of reliance on judicial bodies, that in the case of the EU, it's on a very potential court of justice. It's very much part of the DNA of the European Union, which itself, the story itself of the European Union, its integration through judicialization. So what I want to discuss with you today, it's how this judicialization that in a way worked well within the European borders, because it was congenial to keep a united front among member states. It was effective in even taming those deviating behaviors of the member state. But even more importantly, what judicialization gradually becomes to do was to provide a gateway to reach political objectives that might not have been advanced through majoritarian arenas. And I'm thinking, of course, about the Commission on one side and its political agenda, and the problem of convincing or getting on the same page the Council and the Parliament. So the idea is that this modern meaning, this contemporary meaning, judicialization could be vested with, looking at the example of the European Union, is something that is not just reliance on judicial body whenever there is something controversial on a legal stage, but also to rely on a judicial body to move away, to advance from a political deadlock, and also to pursue a certain line of multilateralism, and also to induce political change. And in this sense, I see that the European Union can be considered as a catalyst for the spreading of judicialization. And I think I'll stop there for now.
Thanks so much, Maria Laura. So I think we've got some interesting points of conversation there already. So on this this sort of foundational question of what judicialization is, I heard something of a distinction, not necessarily a disagreement, but a distinction between judicialization as the instantiation of a particular set of institutions and rules and procedures and so on, but then Quinn's claim, judicialization as a claim in a particular social context, a claim with a purpose, a claim essentially that one ought to behave in a particular way in a particular context. And they point us in slightly different directions, I think, in terms of understanding why it is that judicialization is successful. So that, I think, is a helpful contrast. And in terms of the conditions, which was the second part of that question, I heard, I think, convergence amongst most of the panelists here that in order to explain that, we turn first of all to explaining the position of the US and the EU, right? So these are the key actors, I think, in all of the stories that you tell. Now, there's some disagreement about exactly what the position of each of those actors is. But that, I think, that these are the key protagonists in your stories. It's interesting. I think there's a contrast there a little bit, perhaps, with Quinn's story, which is a sort of a larger story about intellectual history. Less, I think, Karen, maybe about telling a story about a master plan, though I understand what you're saying, but maybe a little more about telling a story of the background ideas about what it takes to build a market and what it takes to protect capital and so on and so forth, which is, again, just a different style of story and one which probably need to integrate both sides of this into a larger story. Let's move on to our next question. And I would note, we can see that we've lost Quinn, and we're hoping that he will join us again in this session. But let me move on to the second question, which is really about the unfolding of this process of judicialization over time, and focusing in on the dynamics which have led us to where we are now. So what are the political and other dynamics which were set in train by this process of judicialization, both within the WTO, but also more generally, because this is not a phenomenon that is confined by any means to the WTO. And in your view, what are the most important of those dynamics for explaining the position that we're now in? And Ignacio, I'm going to turn to you first for this. Thanks, Ignacio.
Thanks a lot, Andrew. Now, I would like to start by indicating that, in my view, the fundamental value of judicialization in the context of the trading system is that it has enhanced respect for the rule of law. I think the authoritative value that panel reports had in the GATT era was totally different with authoritative value that the appellate body report had during its 25 years of life in the context of the WTO. And I think that until recently, you had a system that, although it was contested in certain aspects, it was a system whose legitimacy was generally accepted by all the players within the system. Now, to what extent the decision to move towards a more judicial system has had the unintended consequence of making it more difficult to use the negotiating function of the WTO. This is an argument which is sometimes made and on which, quite frankly, I'm very skeptical. I think the reasons why we have not been able to produce significant negotiated outcomes in the WTO, the reasons for the failure of the Doha development agenda have very little to do, in my view, from the fact that there was a functioning dispute settlement system with the authority of the appellate body. Now, to what extent the consequence of creating the appellate body has been inadvertently to delegate to an autonomous judiciary rulemaking power? Now, first, I would like to emphasize that it was certainly never the intention, neither of the United States nor of the European Union, to use the appellate body as an agent to try to solve the lack of progress in the negotiating role of the WTO. That was never conceived as being the proper role of the appellate body. Now, the real question then is going to be, is it really the case that one can make the argument that because of its own institutional dynamic, there has been overreach or systemic overreach by the appellate body? Now, I would argue that there certainly have been a number of wrong cases. There have certainly been probably a wrong jurisprudential approach on certain issues taken by the appellate body, but I would certainly not be of the view that you can argue that there has been a systemic overreach with the appellate body fulfilling a function of expanding the boundaries of WTO law significantly beyond what the members agreed. Now, something which I always thought would be quite an interesting intellectual experiment would be to have a kind of a Rip Van Winkle experiment. Let's assume someone who was present in all the negotiations of the Uruguay round, that knew everything about GATT jurisprudence, and who goes to sleep for 25 years, and then goes to study what has happened in WTO dispute settlement. What would be the main conclusions that such Rip Van Winkle would actually draw? In my view, that person would probably be much more surprised by the way in which WTO jurisprudence has evolved as far as non-trade concerns is related, how it has been given much broader scope for action by governments. That was the general view before the WTO was created, particularly on issues relating to interface between trade and environment, trade and health. And that would be a much stronger impression than the constraints that the system may have imposed on trade remedy action. Now, I would not say that there have certainly not been a number of to the conclusion that some of the rulings made by the appellate body were probably more expansive than one would have expected. But in overall sense, I would tend to argue that it is not possible to make the case that there has been a general expansive tendency of the appellate body to create law. Now, this brings to a very interesting discussion, but I think we can leave that perhaps for the last question, which is what explains then the decision by the United States to put an end to the functioning of the appellate body? Was this a reaction to this perception about overreach? Was it something that depended more on the new geopolitical context and the transformations that have taken place in the world economy, particularly with the emergence of China? But I think, Andrew, we may want to leave that for the next discussion.
Thank you. Maria Lara.
Okay, I'll keep going with the EU. So if we have to understand, how this process of judicialization unfolded and what are the main effects, I'll be looking at the international trade and international investment law systems, because I think they do provide us with interesting food for thought for this discussion. I'd like to start by saying that the process of judicializations and the effects of judicialization has advanced by the European Union are different, are not the same in the investment and in the trade system. Specifically, I'd say they were more subtle, but also more successful when it comes to trade. And they are more noticeable. They're plainly manifest when it comes to investment. But at least until recently, I'd say that they haven't been as successful as they could have been. I'd say they are plainly evident when it comes to investment, because, for example, I'm thinking about the investment core system as it is included in the investment chapter in the investment chapter of the Free Trade Agreement negotiated with Canada, the CETA agreement, or the investment protection agreement as negotiated with Vietnam, which consists of a two-tier dispute settlement system, very much inspired by the WTO dispute settlement system, and which constitute the short, medium-term solution for the EU to resolve some systemic problems affecting the investment system. And these ideas are also complementary to these ideas. There is the long-term solution of a multilateral investment court. So again, a powerful court deciding over investment claims that has currently been proposed before the UNCITRAL working group, which is in charge of taking care of the reform process of the investor-state dispute settlement. When it comes to trade, I'd say that the way the European Union advanced its own judicializing mindset is more subtle, but is also more successful. I think one partial explanation for this difference between trade and investment lies in the fact that within trade under the WTO, the EU was given the possibility to act as a litigant and as a litigator. Whereas in investment, with the exception of few cases where the EU was invited to join an arbitration as an amicus curiae, it hasn't been given the opportunity to actively litigate before an arbitral tribunal. So this could be one possible explanation for these different results. Being a litigator under the WTO gave the EU the possibility to contribute to the WTO rule development, often by blocking in those who were its preferred interpretation. I think one key moment in time that really marks a point of rupture is it's fairly known case, US Stainless versus Mexico. And specifically, I'm thinking about the appellate body report, which was released in 2008, when for the first time, the WTO appellate body decided to give a new reorientation to the WTO, arguing that identical legal questions should be resolved by a judicial body in a subsequent case in the same way as they were originally decided, absent, of course, cogent reasons. And this decision, this report was very much welcomed by the European Union, but it wasn't particularly welcomed because it could increase, systemic consistency. But I believe it was particularly welcome because of the value the EU attached to the idea of precedent as a sort of wider systemic interest. So we have this value of precedent along with a hierarchically superior position of the appellate body that for the EU were the condition to characterize to determine the WTO orientation and the WTO as a rule-based system. It is here how the story has unfolded. It is on this very point that what the EU was enthusiastic in a way about was also something that was strongly criticized by the US. And I think if we want to make some sort of generalization of how the process of judicialization unfolded, the EU and the US offer these two extremes, because we have on one hand the position of the European Union, which is very much delighted with the idea of having a rule-based order. And on the other, we have the US, which is more inclined to go along with a power-based orientation. So I can say that the process of judicialization in a way unfolded from a starting point that was like the right of power, of sovereign nation exercising powers, and they were on the same level on judicial power. And we gradually move from this point towards what can be described as the power of rights, where judicialization and where judicial authority sometimes not just conflict with political authority, but sometimes took also over political authority. And that's where the problems began.
Thank you. Karen.
So when I laid out the necessary conditions for judicialization, I was giving you a structural argument. And what we've all seemed to agree on was that the decisions to create the institutional enforcement mechanisms were not like some vision of what we have today. But you have then that opportunity. And the question then about ideas is the rights claiming side of the equation. What makes the different actors decide to pursue their agenda through a legal means? And that's when we think of judicialization, it's transferring whatever policy and political agenda you have into a legal arena. Maria Lauras has said a couple of amazing things. She said, well, the EU decides that they want to use a legal route because then they don't have the mess of the parliament and of everybody else. So it becomes politically easier to make certain advances through a legal strategy as opposed to a political strategy. And then she later said, well, the EU likes precedent and a rules-based system. And so again, maybe you could make a political deal in the back room, but you would prefer to have a rules-based assessment, a ruling that can be a precedent that you can apply later. So I think if you want to understand the process, you have to understand why these different actors decide that a legal strategy to take what could be resolved in multiple ways and ask for an authoritative legal ruling. And the danger of having this opportunity structure present is it's just really convenient. And you have different strategies, some long-term, some not at all thought out, some disputes that never should have been raised but are frankly raised for a tit-for-tat reason. If you're going to challenge my beef hormones, I'm going to challenge your bananas, or I'm going to challenge your foreign export tax. And so you get these strategic logics that kick in and no one's paying attention to the larger systemic effect. The reason why I pointed out to not just focus on international institutional developments is because the whole combination you need is enforceable law and someone who will enforce it. So from my perspective, it doesn't matter tremendously that the investment system is an ad hoc system that's done through arbitration, because you have that really powerful New York Convention, which makes the investment system in some ways more potent than the WTO system. It can be activated by an aggrieved investor. You don't even need to get the state on board. And then you can get a legal ruling where you can freeze and claim the assets. And I think that's partly turned into a bit of a Frankenstein monster, because governments don't necessarily control the system as much as they would like to. They want to be having the levers of trying to decide when you resolve something politically or when you resolve something legally. When you allow private actors to initiate this system, then the governments start to lose control of it. And overall, the temptations of using a legal strategy become larger. So what Maria Laura talked about trying to circumvent the political arena by going to legal strategies is fundamentally anti-democratic. And what I think you have now are a lot of pushback against neoliberalism, saying, why are these legal actors making these decisions? Why are they telling us what we can and cannot do? You have the really austere, punitive actions of the IMF, which countries are saying, why did we have to follow these rules? That was not a legalized process. But it's getting mixed up into the whole stew of neoliberalism. And I'm sorry we don't have Quinn here to jump in at this point, but I'll stop for now.
It is a shame, but thank you, Karen. So I heard quite a lot there. So Ignacio, few things there. So you, in terms of the underlying dynamics, I hear, so you put on the table to reject, but put on the table this dynamic of judicial overreach, which is obviously central to the conversation, and said, well, actually, that's not really what we're seeing within the WTO in your view. What I heard from you also, Ignacio, I think was also another claim about a sort of a structural dynamic, which is that once you establish this sort of system, more and more different kinds of claims tend to be brought to it in a way that was not anticipated by the negotiators or the architects. I think that's what I heard implicit in your claim about the expansion in terms of non-trade concerns. Feel free to come back on that.
No,
yes, please.
No, thanks, Andrew. I would like to come back on that and also to comment on something that Karen and Maria Laura mentioned. Now, in my view, it is clear that on a number of areas, the appellate body has taken certain decisions that probably were more constraining than what the negotiators thought they had actually agreed. And I think that that's probably just essentially relating to some issues relating to trade remedies. On the other hand, if you actually look into the jurisprudence on issues relating to non-trade concerns, I would argue that, on the contrary, what the appellate body has been doing has been reading the provisions of the Uruguay round agreements and the basic provisions of the GATT Article 3 and Article 20 in a manner that gave broader scope for countries to take action than what would have been the general consensus about how those provisions were going to be read when they were actually negotiated. So that's why I think that the story is much more complicated than a story about overreach. I mean, I certainly can understand why there's a strong feeling among some in the United States on some of the decisions that have been taken in areas like safeguards, or some of the decisions that have been taken on certain aspects of anti-dumping, like zeroing. But I think it's a bit different to say that that implies that you have had a situation in which you have had an institution that systematically has been limiting the scope for members to take action, which is where I think that the definition by Karen of judicialization is very important. I mean, I think that certainly if the key element that you have an effective system of third-party adjudication in which parties can bring their claims, and their claims are going to be adjudicated with finality. Yes, I think that's certainly something that was very much the intention of those who negotiated the establishment of the WTO dispute settlement system. Now, if the concept of judicialization is something more teleological, that implies that because you believe that certain objectives can only be achieved if judicial institutions push the boundaries beyond what was initially agreed, because that's the only way to make political progress on certain areas. I would argue that was certainly never the view from the European Commission or from the European Union as what we saw being the proper role of international adjudication. I think it's always important to distinguish what is considered to be the legitimate role of the ECJ within the European legal system, and what is the view of the EU about what is the proper role of international adjudicating bodies.
Thanks, Ignacio. I think that, yes, please.
Well, can I just say something because the other thing which I found very interesting in what Maria Laura said is this contrast between power-based and rule-based diplomacy. Of course, the intellectual creator of that concept was an American, John Jackson. So I think that if you actually want to look into where came the intellectual inspiration for the establishment of a more rule-based system of adjudication, it really came from the United States.
Thank you. Thank you. So I hear in the first part of your response, I hear, I think I hear very clearly a pushback against oversimplified claims that this is all about judicial overreach. I take that point. Absolutely. And Maria Laura, sorry, just to reflect back a little bit, and even should you want to provide an opportunity to both you and Karen to respond. So Maria Laura, I hear partly a dynamic here about the iterative entrenchment of rule of law values through judicialized dispute settlement in different treaty arrangements around the world, and I wonder, I wonder whether that takes us towards, whether that leads us in the direction of really thinking about judicialization as not exactly a unidirectional process, but one which has its own inertia. I wonder about that. But certainly part of your story, Maria Laura, seems to be central to this, does seem to be this different vision, which Ignacio challenges, but a different vision of what the proper role of judicial institutions are. And the contest, I think the contest between the EU and the US in your story about that seems to be a central driver of the dynamics. And then Karen, I heard something different again from you, I think, which was really that the dynamics of judicialization depend very much on what the actors and their particular projects are over time. And it's simply a matter of working out which of their outcomes are best achieved or most likely to be successfully achieved through judicial means as opposed to other means. That's really the question we need to ask. And I suppose we would also need to ask, why is it that those actors believe that to be the case? Because that ultimately perceptions is what we're not interested in. And the point you made was that the actors who matter are really, and I'm simplifying your point, but the actors who matter are really those who initiate the cases. And that's in a sense, the structural point. Thanks. I think there's a lot on the table there. And unless I see a wave from Maria Laura or Karen, I'm going to press on, which I don't, I'm going to press on to our third question, which is really our third and final question, which is really looking now at the question of backlash and the futures that we can imagine from here. So, this is the set of questions. Are we living through a backlash against judicialization in international relations? We may not be. Are we? If so, where might we expect it to take us? And more generally, what does it tell us, if anything, about the fragility or stability of judicial institutions in general as a framework for the conduct of international relations? And actually, Karen, I'm going to turn to you first in the absence of Quinn. So thanks, Karen.
So Andrew, you summed up my argument right. And as Ignacio was talking, I don't think it's the judges who do the overreach. I think it's the litigants who bring cases they probably shouldn't bring. Because it becomes very convenient for a strategic moment. So I talked about the structural necessary conditions. Let me give you the permissive condition that allows judicialization, is that one has to believe that legality, the quality of something being legal, is important, is important for the legitimacy. And so if you think you've got these rules, you've got an enforcement mechanism, you have a rules-based system, then a legal means to resolve the dispute seems completely appropriate. Even if maybe sometimes the devil in the back of your head is saying it'd be better if we do this politically. So, why did the whole safeguards issue get turned into something that you litigated? And even the issue of balance of payments, which was never supposed to be litigated in the WTO, all of a sudden you get the US bringing the case against India. It becomes very tempting. And maybe we then want to roll back the decision to say legal solutions are the appropriate solutions. The problem, though, we're now facing, and I should say I've been writing about backlash for 20 years, backlash against international courts, but I've been really unsatisfied with the whole theory and conversation that we had to work with. I just thought it was getting us nowhere. So I went back with Mikko Zern and rethought entirely what it means for there to be a backlash politics. And we took seriously the idea of backlash, of the word, it's returning back to something. And we think of it as a political response that's oriented around a retrograde imaginary. You want to go back to something. And what you want to go back to at this time, right now, the populists want to go back to, is national sovereignty. And here, this is where Quinn started us, is this idea that we should be the masters of what our international economic entanglements are. And we should be able to turn on and off the spigot of international trade. Now, of course, that's not what the WTO system is all about. It's precisely not to allow countries to just turn on and off in a very discriminatory way. And I'm a fan of the WTO system. So I think when we start to reflect on what the Trump strategy was, we're going to say, well, we don't really want that system. So the permissive conditions then of valuing legality, valuing a rules-based system, that entire agenda from soup to nuts is what the populists are challenging. They don't want domestic legal constraints. They don't want international legal constraints. They want to return to the imaginary of a national sovereignty, as that was a world that was better. The Europeans remember far better than the Americans how that's not at all a world that was better. That's a world that leads to conflict. It's a world that leads to war. It's a world, nationalism is a beast you don't necessarily want to unleash. And so they're the ones holding on to a rules-based system, along with Biden and the generation and people like me. But it is this contestation over ideas and over what you want for the international system and what you want for the domestic system.
Thank you, Karen. Ignacio.
Well, I would certainly agree with Karen that there has been the political backlash against globalization, against international institutions. And without that ideological element, it is likely that we would not be in the situation that we currently are in terms of the dismantlement of the appellate body. I mean, I personally think that if Hillary Clinton had won the elections and the new USTR would have been, let's say, Mike Froman, we would certainly have had a lot of tensions within the system. I think there would have been a lot of pressure relating to the reappointment of members of the appellate body, but it is unlikely that we would be in the situation that we currently are. The problem is that together with this political backlash, there's also something which is a little bit more structured, which is the fact that we are now entering into an era of geopolitical conflict between the United States and China. And that linked to this geopolitical context, there's some fundamental questions about to what extent the relationship with China can be managed on the basis of rules or not. And that's what I think the reason why it is certainly going to be much more difficult than otherwise would be to find a way of trying to restore a more judicial system into the WTO. Now, I personally see three possible scenarios. The preferred one, the one certainly that the European Union would strongly advocate, would be a reform scenario, where you would be able to have again a judicialized functioning dispute settlement system in the WTO, although likely to be significantly more restrained than the previous one before the dismantlement of the appellate body. Now, exactly what this reform would imply is not the topic for this panel. Ideally, this could actually be combined with some agreement about the rules that manage the interface between state capitalism and other forms of economic management of the economy. But this is going to be even more difficult than actually finding a way to have again the functioning dispute settlement system. So this is the reform scenario. Now, the second one, reading what Karen has been writing, I have decided to call it the Sleeping Beauty scenario, which is actually in a scenario in which, no, it is not possible for the time being to find a way forward to restore a functioning dispute settlement system in the WTO, but where there are different elements that somehow keep elements of judicialization within the field of international economic relationship. This would be a combination of the multi-party interim arbitration agreement among those parties that have subscribed to it. This would be the elements of binding dispute settlement, which are part of preferential trade agreements. It would be ad hoc arbitration as another alternative. Quite frankly, I think such a system is going to be much less legitimate and much less effective than the one that we used to have under the WTO. So my impression is that this Sleeping Beauty scenario may be a second best in case it is not possible to find a way forward towards the reform scenario, but it is unstable and it is unlikely to be sustainable for a long time. And then it's a pity that Quinn is not here, because I read that he was actually thinking about a scenario which I think he called globalization minus China. Now, I tend to think that that is a rather unlikely scenario, but I certainly know that there are those who would be thinking about what about developing the rules only among market-based economies and establishing a system of adjudication among market-based economies, and then dealing with China on a different basis. We will be much more a power-based approach to the relationship with China. I think this is quite complicated. In the extreme, it would imply those countries abandoning the WTO. In the less extreme, it would imply some form of deep and comprehensive free trade agreement among market-based economies. And I tend to think that I do not really see at this point in time the political conditions for that. And in any case, I suspect that this would actually be also quite unstable and prone to conflict. So all in all, I think we are going to see some time of turbulence. I mean, I still hope that there is the possibility of moving in the direction of a reform scenario, but it's certainly not going to be easy, because the whole geopolitical context of the US-China conflict inevitably is going to have an impact in terms of what can be agreed in terms of judicialization.
Maria Lara.
Well, I think I completely agree with Karen. I mean, it's not like, it's not like tribunals are asking for resolving these political problems, but it's, in a way, it could be seen as a strategy, as some sort of blame defection strategy, because, if the hot potatoes is shift from a political scenario to a judicial scenario, and this galvanized, fueled by this mythological status of rights, at certain point, political actors, they're going to say, look, it's not us, there was a problem, it was the judicial body, that's how the rules are, and that's what the rules are telling us to do. So it's, I would say, in a way, judicialization is a product of globalization, because at that point, litigants prefer to find other ways to deal with a problem that's predominantly political, even more than legal. But anyway, having said that, I don't think that judicialization per se is wrong or is something, malicious. As I was saying at the beginning, there may be, from an output perspective, judicialization indeed ensure obedience to the rules. It was congenial for the European Union itself to keep a united front among member states. So in a way, there are some merits. There are some merit that should be recognized to the judicializing process. And whenever this process is convenient, I think states should lean on this process. However, I also believe that blind faith in judicialization may not be such a good idea, especially in multilateral settings. And I think the appellate body crisis, if one thing that crisis plainly demonstrate us, prove us, is that there may be limits for the international community in accepting judicial decisions as a substitute for policy making. So whenever judicial decisions are detrimental to policy-making decision, at that point, judicialization is not working. And I want to conclude by sharing with you a story that I read, that I came across while I was reading some WTO meetings document. And it's a fable that was told actually by the delegate of the European Union. And the story is, it's pretty short. It's about a frog that was suddenly put into boiling water, suddenly being the operative word. And of course, as soon as the frog is put into boiling water, it will jump out. But then the story went on. If the frog is put into tepid water, it won't realize the danger until it will be cooked to death. But then the delegate went on and explained that apparently this story is false, because as soon as the frog will realize that the water is getting hot, is about to boil, it will jump out anyway. So I think that the frog for our discussion could be a metaphor for political policy making for the state. And the water, the boiling water, could be a metaphor for judicialization. So I'd say it's not about finding the perfect recipe to cook the frog to death, but it's more, find some sort of balance between judicial authority and political authority, and to understand when one is convenient for the other, and when actually judicialization could even could be an instrument indeed to progress for further integration, to advance economic or even judicial integration, and when it's just an infringement into the domestic sphere of a state.
Thank you, Maria Laura. And I have to say, I, for one, am very pleased to hear that frogs have a greater sense of self-preservation than I had been led to believe earlier. So thanks very much. So again, I heard a few different things. So Maria Laura, right there, one thing I took from that, and I know there was a lot in what you said, but, was in a sense the simple and powerful response that, judicial dispute settlement of a particular kind has a certain functional appeal in particular conditions of globalization. It retains that particular functional appeal, and where that continues, then we should expect it still to maintain its appeal and to continue as an option, at least. And I take that point. There's an interesting contrast to be drawn, and maybe Karen, I'll come back to you briefly here. So, one question is the set of questions which, Ignacio, you responded to, which is, within the WTO and similar treaty systems, what would we imagine the institutional structure to be? And you, I think, very clearly and helpfully laid out a series of possibilities. There's a complementary but somewhat different question about, given a certain set of institutional infrastructures, where within a larger space of different governance regimes, where might we expect significant decisions to be made? Is it the case that what we're seeing is not just a transformation of institutional structures within treaty regimes, but a shifting in importance between, say, treaty regimes or the private side of economic governance or other spaces of decision-making? And I think, Karen, can I just very briefly put you on the spot to say something about that? Because I know it's something that you've thought about.
Yeah, so I think that it's not like there's a one-time balance. Markets are dynamic. So instead, you have to be having someone who is paying attention to the balance between legal and political solutions. And the thing is, when you have the opportunity structure to litigate, and when you let private lawyers be the actors who get to decide when to trigger it, but even what the law should be, that to me is the recipe for problems. So when I look at Katerina Pistor's story about the Code of Capitalism, that code is primarily written by the self-interested bankers and the lawyers who say, well, what kind of rules would I most like? And it's only if the state is going to step up and make those rules enforceable, or say, hey, wait, those are not the rules that we want. It has to be the state, or internationally the collectivity of states, that are trying to put some balance into the system. And the problem we have is that governments are falling down on the job, maybe because they drank the neoliberalism Kool-Aid and they think that markets can do it better, or maybe because they're so politically tied in knots. But basically, for a rules-based system, which let me just put a little footnote on that and say that Peter Beinart had this really interesting op-ed in the New York Times when he said, you know, we have a rules-based system. It's called international law. Why aren't you talking about international law? And why are you talking instead about a rules-based system? And he says that that's a very artful dodge. He picked up on a stream by Paul Post, who asked this question about where did this word, the rules-based system, come from? And why are we letting it take over the international law as the answer? And I think that states do want a rules-based system because the alternative is they have to use force and coercion and arm twisting. And so you'd rather have a rules-based system. But there are many ways to get it. You can get it through private actors creating their own convenient contracts that they enforce through arbitration. You can get it through bilateralism, which is what China's making with its Belt Road Initiative, which allows power to dominate. You can get it through multilateral rulemaking, which then has a larger set of actors that are participating into it. If you let the private actors decide the rules and the enforcement mechanisms, I think that is a recipe for trouble. But that's why I put in front of you that complex that says global economic law is made by a combination of international multilateral law, domestic extraterritorial law, and private contracts. But the private contracts can only make the rules if states let them make the rules and make them enforceable. Because if they're not enforceable, then there's no value to the private actors. So it was, you know, if Quinn was here, the system that he was describing of protecting dominion through internationally enforceable binding rules that were there to protect private property. And the actors themselves are a bit agnostic. If they could get an international system that they most like that enforced the rules they wanted, then they would go with that. But if they can't, then they'll go with bilateral. And if they can't, then they'll go with private with an ad hoc enforcement mechanism. And so I think someone's got to be paying attention to this public-private balance, and you can't just turn it over to the private actors to. It's not their job to pay attention to the public, and they don't do a good job of it, even if it was their job.
Thanks so much. Okay, so I think that should be the end of our recorded session, and we should give our participants in the live Q&A session an opportunity to ask their questions. Thank you so much to all of you for your insights, for starting off our conversation so well today. Thank you, Ignacio. Thank you, Karen. Thank you, Quinn. Thank you, Maria Laura. And here now, I'm going to pass over to you, Maria Laura, please, to moderate the session of question and answer. Thank you.
Well, thank you very much, Andrew, for doing an excellent job in moderating this panel. It was a pleasure to have you with us today. So thank you.
Thanks, everyone.
Hello, we're now live. Thank you, Andrew. Karen, you can come on stage if you want. So we'll be very brief. Thanks everyone for bearing with us with technical issues. As they say, only the brave until the very end. I will try to combine a few comments together. We don't have much time because there is also a networking session that is about to start. So I will try to combine a few comments, and then I'll give you, Ignacio, Karen, and myself the possibility to pick up the question we will like the most. So I think that it was a very interactive, there was a very interactive exchange in the chat. So thank you very much for this, and apologize for not allowing anyone to come on stage. So I think the first set of comments, in a way, invite us to reflect on, let's say, two conflict forces. Because on one hand, we can say that there's been some attempts to delegalize international economic relations. And I'm thinking especially about the changing in the geoeconomic shiftings between how the powers have been shifting between the US and China. But on the other hand, it seems to be the case that these two settlement mechanisms are very much alive. And as Geraldo was rightly pointed out, we have many legal instruments actually permitting for dispute settlement. It's not just the WTO, but we also have NAFTA, we have investment agreement, we have free trade agreements, we have regional agreements. So if we look ahead, and I'm borrowing now from Ricardo questions, one question that the audience has invited us to react on is whether issues like climate change, digitalization, that are indeed transnational issues, do you think that it is possible to address this problem without without recurring to any judicial settlement mechanism? Have we learned enough from the problems currently experienced by having too much or having enough judicialization? So have we learned, is there some lesson for us to prevent the next backlash, as James was asking? Then, of course, there is another big theme around the appellate body overreaching. So I'll leave you this to Karen and Ignacio if you want to react. And lastly, I think another set of comments that were suggested, that came out in the discussion in the chat, refer to the relationships between municipal judges and international adjudicators. So how should the two interact? And I'm not just thinking about, for example, WTO adjudicators, but I'm also thinking about investment dispute and investment arbitration. Have they ever stepped over? Have they ever exceeded what was their mandate? As they ever exceeded what were prescribed by the rules, and how this relation could be handled. So I think these were the three main areas that were touched upon in the chat by our attendees. And I'll give you now the floor to Karen. You're free to start with whatever question you prefer. Thank you.
So I actually think that the WTO system, as it's designed, is a pretty good system. It's just that it's not working. So if you look at what is this ratcheting up dispute with the United States over zeroing, I mean, the United States signaled over and over again, I am not okay with this outcome. And the dispute settlement body could have said, okay, let's work out a political compromise. Let's put all of these safeguards. But the process is sclerotic. It's not working as it should function, which is climate change. Ideally, the states would get together and say, we have to work climate change into the system of rules. We have to make the WTO fit with the Paris Accords. We have to, they even have everything they need for sustainable development. We have to allow Article 20 cases to go there. And they should make the decision of how they're going to deal with climate change. Do I expect that to happen? No. I don't think they're politically going to be able to get together. And so maybe that will be decided by the dispute settlement body. But that just creates the opportunity for domestic actors to say, overreach. This isn't what we agreed to. And why is the WTO making us do this? You know, it just gets caught up in politics. And while I totally understand the legal argument, and I don't blame the judges, they're kind of stuck between a rock and a hard place. This is the reality that we have. And that's what I worry about. The problem is that if the WTO is not the forum that resolves these disputes, it will still get resolved either by a political power force. The US says, I'm just not doing it, or China says, I'm just not doing it, or through a PTA. I mean, I thought that the Trans-Pacific Partnership had some smart elements to it, but if you looked at the IP rules and the dispute settlement system that the US put into the Trans-Pacific Partnership, that would have been terrible. So if you let these bilateral forms go, if you let private interest, which was the IP interest that put in the IP protocol of the Trans-Pacific Partnership, you can get into a lot of trouble. All I'm saying is that we have a political legal mechanism that doesn't work like it should. And the lawyers can say, well, you know, that's for the politicians to resolve. That's not our problem. We just apply the facts and the law. Well, it is your problem, because then the system is going to become very, very contested. We'll stop there.
Ignacio. Your turn.
Okay, no, thank you very much. I agree with what Karen has just said. I mean, I have to say that despite the geopolitical conflict, despite the tensions, I tend to be, in overall terms, optimistic. To restart a functioning dispute settlement system in the WTO. And I tend to be optimistic because I think that in a global economy, if you don't actually have a legitimate and effective mechanism to adjudicate disputes, you are going to have a lot of instability. You are going to have a lot of conflicts which cannot properly be managed. And that's the fundamental role that the WTO dispute settlement system has been performing over the last 25 years. I mean, clearly there has to be a course correction, there has to be adjustments, but I think that actually it is difficult to imagine how a pure geoeconomic order could actually be managed without actually having a huge increase in instability and conflict. I mean, we experienced a non-judicialized world between the 70s and the 90s, and it was not a pretty picture in terms of how trade relations were being managed. And we are actually now in a much more difficult and problematic situation than the one that we had at that point in time. Now, I think it was very interesting that you mentioned the example of climate change. Some people would argue that the WTO rules are a constraint and that therefore it is better for the protection of the climate not to have a functioning WTO dispute settlement system. I would pretty profoundly disagree with that. I think the more that you actually have a functioning WTO dispute settlement system, the more that you are able to be sure that you can take action to protect the environment, that you can be protected against tit-for-tat retaliation, and that at the end of the day, you may need to be able to adjust your action at the margins. But so far, the experience of 25 years of WTO dispute settlement is that in no case has the WTO dispute settlement system put in question the right of countries to take action to protect the environment. So from that point of view, my sense is that having the more that you have a system of dispute settlement which is legitimate, which is effective, the more that you can actually also ensure that you can actually take actions which are necessary to fulfill the non-trade concerns. It is going to be, of course, much more complicated when it comes to arbitrating disputes which have to do with the interface between industrial policies, because that is the fundamental other area of conflict in the system. And that's why I think that ideally it would actually be good if we could actually find a way of agreeing among the key players in the system about the proper interface of industrial policies. But I think that's going to be probably quite difficult to do. I think that we should try, and that also has some implications about the right way for the adjudication system to function.
Okay, thank you very much. I think I'm just going to conclude by simply saying that sometimes the problem is not just in the process, and I am, of course, inspired by what's happening in the international investment regime and the reform process that has been carried out by UNCITRAL. So yes, there is certainly room for improvement when it comes to international adjudication, and in that case, when it comes to investment arbitration. But I don't think that the problem is just there or is just going to be entirely solved if we are going to, I don't know, institutionalize the investment court system, for example, with a multilateral investment court, because I think much of the problems will remain, still is and will remain in the way the investment treaties are drafted. So I think a proper dosage of intervention at procedural level, depending on the system, of course, should be also accompanied by some restructuring at substantive level. So the two goes hand in hand. So we cannot, I mean, it takes two to tango. So that's probably something that we should definitely keep thinking and keep discussing. I think we are way beyond our allocated time. I apologize again for the technical problems we were experiencing at the beginning. thank you very much for coming today and for joining us in this discussion. There is also a networking session that has already started. So perhaps if you want to continue the discussion there, I just sent you the information. And lastly, I want to thank especially Andrew, although he's not here with us today, for his excellent job in moderating this panel, and a huge and heartfelt thanks to Karen and Ignacio. It was a real pleasure and Quinn, as long as he was with us, to share this panel with you. I would have loved to have this conversation in person, and I hope we will be able to meet in the real world soon. Thank you very much. Thank you. Thank you.